There you go.
Good.
Hey, how's it going? Time no see.
Huh?
I said, long time no see.
Yeah, how you doing?
Pretty good. How about yourself?
you doing?
Good, how are you?
Yes, this is, I decided with two sets on which side.
No, no one's been in here.
No, I'm right.
It looks like you're making the decision
I'm
here.
glad. Well, you didn't get my other text. Oh, you didn't. I said. Oh, you know what I already did. I said, who is it? It's Larry, and then you didn't respond. So I said, boy, how quickly we forget. Are you doing, validation? Okay, that's fine. Oh, yeah. I'm surprised nobody knows it. Yeah.
Yes, sir, I'm with the statesman.
Oh, it's nice.
Yes, sir. Sky,
I'm Larry.
Larry, nice to meet you, sir. Are you with the city legal?
No, I'm contract city. Used to be.
Oh, really? Okay. And bring you back in.
Came back in.
Yeah, it's been a long one going.
It has, hopefully.
Yeah.
I'm surprised. Walking here, your citizens in here.
Right, I mean, normally, but I didn't see it announced until yesterday, so I don't know whenever y'all originally. Yeah, it might have been, but I didn't see it posted until yesterday. Check. And then, yeah, I just, saw it. It's the first time.
Oh, yeah.
Yeah.
We sat through three. And I got
Okay.
answered. Yeah, but if you really. So they can.
They got so many different organizations, and like everything is from some different one. I mean, the big one that they have now is Equity Action.
Yeah.
There's the big ones right now, yeah, but their names change every. It's like the same people, different names.
Oh, well. That's why.
Yeah, really. And that must be far.
Yeah.
The, are you expected, to be pretty productive today since y'all had such a long time?
Well, yeah, I think.
Yeah.
Overstated, I think. Some.
Yeah, because I mean, other than the percent stuff, it's like, I haven't even seen that, you know what I mean? That you weren't even getting. Yeah. Yeah. So I mean, I guess y'all must have gotten close up.
Well, see. Same. Yeah, I'm not expecting as much.
Oh, wow. It's not the first time.
Oh, yeah.
Yeah, no, the other ones are, like, you know, like at lunch half the time, it's like, all right, we're good.
Yeah, yeah. Well, and I'm often wrong.
Yeah. Don't quote you on that. I mean,
So, but anyway, that's kind of what I think everybody's thinking.
And then did I see too, I think there's another schedule for next week too.
There is, of course, those that we schedule out, all the people on.
Oh, what happens today?
But everybody's optimistic that. You know,
Yeah. An interesting topic too, right, with that new chief coming in.
yeah,
Possibly getting close to this.
yeah. Chief.
I don't think, I was like, yeah, it sounds like it's probably gonna be this week. They announced the finalists. Who's- Sound like, I think everybody's listening to it.
Yeah.
They got the rooms bugged now. Thought it was getting close, you know, it was working.
Just did. You talking about not being muted? Just got the. Yeah. Sure. Same. That's right.
So welcome, nice to see you again. It's my understanding that you've talked a little bit ahead of time as to how to lay things out today, and we're gonna start with subcommittee work.
Yes.
And are you gonna do that, Tyler, or is Ron gonna do that? What's the intent?
Well, purposes, we'll walk through things of which can be TA'd or nobody has any changes to the contract. Once, then, I'll lay out the 16, 17, and 19 on Prop A issues, and then Christopher, we get past all that, we'll lay out the association's economic plan.
That sounds good. Go forward. Did we want to do a small recap of kind of where we're at and so what we were trying to accomplish at the very beginning of this negotiation process? Do you need to do that for?
Go ahead.
Well,
Oh, you want me to do it?
it's up to you or me. To stay where we're at. Obviously, we know code 215 is now in place, right?
Yes.
And then there are 4 buckets of things that we've identified that we can only accomplish via the contract because it requires us to amend or modify 143. Or in the legal jargon, we say preempt, right?
Yes.
So Article 16, 17, and 19 is where those 4 buckets are. And it sounds like you're gonna go through them when you get to those articles.
Yes. Yeah, we've said from the beginning, voters approved Prop A, that's important. It's out there in it. People wrote it, may or may not be not knowledgeable about where all the conflicts would then fall and things that are in civil service law. So, like I said, we've identified 4 things in the proposition in our ordinance, of which would require the association to agree to preempt so that it wouldn't be in conflict with the ordinance. We've identified those things, and just about everything else, except for the economic side, I don't see any real. If you just want it for the purposes of video or audio, I can just stop and go through, and if you want, I can just give you the ones verbally that, of which I don't think there's any contested issue. Maybe.
So I think because, although we're out of contract and starting with new language, there are some things that have been changed from a historical perspective. They're not huge monumentous issues, the ones that were in the subcommittee, we intentionally made those the non-controversial items.
Yeah.
But I think just for the record, we should kind of walk through it so that we stay for the record on those.
So why don't I'll start, we can start walking through articles, do one at a time, say what we think, if there's anything, and then add anything from the city side. What, this was a subcommittee group that, since the last time when it was announced, we worked real hard to go through all those non-controversial articles, to try to come to an agreement on those, so. Walk through. Article 1 is the preamble. Obviously, the only thing that's really missing still from there is just the effective date, so that's obviously, if we're able to get to a final contract, but the rest of the verbiage, we're good with, it's pretty similar to what is going to be past contracts.
Correct.
In Article 2, that's definitions. And we adjusted our definition 3, which is authorized association representative, just clarified it a little bit to the president or their designee, just to simplify and make it more in line with what our bylaws are. And that's pretty much the definitions that we had really any changes to.
No, I agree with that completely, and I think what we're just calling these are joint recommendations of the subcommittee, which was 2 people from their side, 2 people from our side, and we just kind of dug in. And what Tyler is going through is what we're calling the joint recommendation.
Yes, yeah, and really appreciate the back and forth we had with all that.
Yeah.
And to get to where we are today.
Agreed.
It's been a lot of work.
Yeah.
All right. 3, recognition in our original proposal in the first meeting, we had a list of things that, we wanted notice from the department by notice to the association. The city has been working on some steps there.
Yes, and so of those things, I know that Chief Greenwald and your APA president have worked and actually gotten, I think, all of them accomplished already. So not a contractual issue from the city perspective, but we were happy to do them and just, they've already been done.
And just for the, for people watching, those are just things like notices when people get transferred in the department, or
Exactly.
notices of a change of duty status, or things like that, just things that will help the association be more informed. It's things that the department, in a bunch of different variable ways, were sending to us, but this way, we just formulated one way for them to send all of it to us to make sure that it's clear and easier on the city, easier on us. Article 4, the management rights, this is very similar to what has been in there, and then we had some discussions on independent investigation as well.
You want to get immunity to that.
Yeah.
Right, yeah, so similar to the article we just did, the APA had asked that we put into the contract certain language of what we weren't intending to do here. And again, our answer was, we agree with you, but that's not contract language, but we, for the record, are happy to state that. So I think you have that.
For independent
Yes,
investigation.
well, yeah.
Yeah, what we mean specifically is that it is truly an outside, fully independent investigation. And I don't know if you need any additional information from us or our intent statement.
But I think you also wanted that it's, we're not intending to use cars for former employees of the city. We're not talking about appointees of city boards. We're not going anywhere different than we were before. It's the same, in fact, definition that we had used previously.
In Article 5, it's non-discrimination. Most of the language is very similar. We did clarify in Section 1 just that assistant department head is included in the definition of officer for this section, just saying that assistant chiefs can't be discriminated against either. Just like city halls, everything else allows everything. It's just a clarification. Did you guys have anything else?
No, I mean, just for the public consumption, the reason that's in here is because for most of the articles, they're excluded unless they are specifically included. So the language is just here specifically included. Y'all know that, but I
Yes.
was watching.
Yes. In Article 6, on union dues and check off, couple things in here that were just changes and something that I noticed this morning, and I wanted to just throw it out there and then you guys can review, but are in Section 1C, it doesn't change anything with the article, but it says in there that exempt deductions for Austin Cops for Charities. So they are in the process of changing their name, which was approved by the board. And I'll send this to you as well, but just changing the language to the Austin Police Benevolence Foundation, formerly known as Austin Cops for Charities. They're still in the process of changing all of that. So it's still Austin Cops for Charities on the city form, but eventually we're going to change all that. So just to keep it in line with
What's the new name?
the Austin Police Benevolence Foundation. But formerly known as Austin Cops for Charities. Just keep both of them in there. It's the same organization. They're just updating their name.
And so the only difference for that is that they are exempt from the deductions.
Yeah, so every other deduction, the city takes a cost of them, what it costs the city to make that happen and send those deductions for the Austin Police Association or 100 Club or whatever it is. The Austin Cops for Charities, since that's the charitable organization, the city does not take a deduction for that work.
Okay, yeah, we won't have a problem with that, but if indeed it is changed prior to this contract,
Then
before
we
city
can,
council, we can just do
we can
that
do that.
as a typo. After that, you'll have to go kind of through the more formal process if it takes longer.
and the other thing there was just, we increased in Section 3 that if we have a member of our association die, anytime, not just a line of duty death, but the officers, $25, we bump that up to a $40 deduction in there, and that if there's unfortunate circumstance where two die in the same pay period, that they split it up, among 2 pay periods. And then our contract, the evergreen on this one was submitted that it would be 24 months. That's the deadline of the contract deadline.
The only other thing I would say on this is there's a couple of changes in the timing for payroll, but for public consumption, it's not gonna make a difference, but just clerical changes.
We're gonna skip 7 with 8. We're gonna go all the way to 12. Article 12 is association communication. One of the things we just added on from the association side is just an ability to add electronic messaging system where we have bulletin boards currently in the substation. So at some point, if we're want to or need the upgrade in technology, we added that in there to help us communicate with our members a little more efficiently than just a bulletin board. 21st century, some technology, something. Did you guys have anything?
Just a couple of minor things, just, ensuring that when that technology happens, that's on the association as far as paying for all of those. It's not a citizen cost of any sort. Minor change in definition of the president, again, according to your bylaws versus the executive board. That's about it.
Article 13 is promotions. This one is we haven't really made many changes from what we initially submitted. I think the city and association were very much on the same page on promotions and getting back to the promotion process that we've always had under contract up until the rank of commander, and then those are the new changes that came from past discussions when we were under bargaining, adding some requirements for commanders, extra training classes, probationary period for commanders once they promote, but corporals, detectives, sergeants, lieutenants are the same process that they've been under past contracts.
Okay, so let me go through that in a bit more detail. The commanders is kind of the breakthrough that nobody in the state of Texas has. It's the probationary period, and it's a huge step on the part of the union to do that. We are hugely appreciative of that. On the other ones, although it's the same process, if you recall, and I know you do, it's just a matter of verbalizing it for the community and for the council members who have specifically elicited this information. We have changed how this is done in accordance with the Kroll report. And why we did that and how we did that is to increase diversification. And that's in the applicant pool and in the promotional pool for applications. And what the Kroll report basically said is that it is very beneficial as far as diversity to not have your pass-fail score until you take the written score and add it to the assessment score, and then have your total cumulative score being the pass-fail score. Prior to that, and although we talked about it in the past, it had never been implemented quite that way, that you actually don't have the pass-fail until you have the cumulative score. So that is a huge implementation of the Kroll report that we actually spent a lot of time in caucuses in the past working on, and are very proud of that. The other portion of that is the weighting of the assessment versus the written, and that's now going to the 50-50 weighting instead of it had been 70-30 at one point and a 60-40 at one point. And also in accordance with the Kroll report, we followed the recommendations to increase the diversity of the promotional.
Yeah, and the Kroll report, just also for public consumption, that was an independent study that was done in 2021, and it looked at the practices and the policies of APD's use of force, their public interaction, recruitment, selection, and promotions, and wanted to evaluate whether those policies or practices, whether it had an effect, if any, on how it impacted the historically underrepresented groups such as women and people of color. And so I'm just speaking a little bit more on this because I want to applaud both sides' efforts in this, what Sarah already said, monumental promotion article, so that way we can keep and sustain diversity within the department. So this is a great article.
It's, and they did agree with that. We did, we're glad that we were able to work through the promotion process that we think will be better for our department, provide better leadership in the department. Ensure that we maintain that, that high standard that the Austin Police Department has and the association supports.
Well, and I think we've had such good cooperation that we are also pleased with ourselves that we think everybody else knows how much work we put into this. And I really don't think they do. And how the changes that we've made really should be on a long-term basis helpful to both the department and the association.
Are there changes to what we have on the page? Do you offer new things or just explaining what's in it?
I'm explaining what's in it.
I didn't focus on this at all.
No, we didn't change,
You know, because there's been so much work done prior.
And
And
yeah,
then we just changed the date. You're saying what's in, I'm thinking, well, I hadn't read it.
no.
No, this is just a refresher course on what a good job it was when it was done.
Yes.
No, that,
That's
It's
2 years in hard work.
very well done, professional system, very Austin centric, I would say. So,
For sure.
good, if everybody's happy.
Everybody's.
Everybody's happy. And the.
Whoa, there's a lot of word here.
just a recap of work.
Oh,
we've
okay.
done in the past, Setting up the.
It's years of work in the making.
Yeah, literally years of work. The report came out in 2021 and we started working with it since then.
Good, all right.
Moved to Article 14, hiring, process.
Hold on a second.
Yeah.
Yeah, this is. I don't know where we're at this minute, see. This is just basically some language. The city has placed a number of things about probationary officers thought was too repetitive, because we have a definition on it that clarifies. Yeah. In this place is one of the 4 places it was placed, but I'm saying here it's probably needed, because it's just saying that if your probationary period is extended, your period of being an at-will worker is extended along with it. So I don't know where, you would give me some counter, then I think I'd change it. So I'm not quite sure where we're at. I don't think we disagree about this, but are you, what I sent you, is that where we're at?
So just to clarify, the probationary period, what we're talking about is that there are instances when a probationary officer's probation can be extended beyond the year, but that extension for however long it may be is still an at-will status. We are saying the same thing. I think we're just down into specific language. So I will get with our team and make sure we've got the right language, and then we can.
Yeah, we're not disagreeing on intent.
Yeah.
I'm listening to-
Yeah, we're on the same page.
Article 15 is drug testing and.
Oh, I'm sorry, can we just go back to
Oh,
Article
sorry.
14 for a minute? We, the state statute had changed on the maximum age of applicants. So
Yeah.
in the past, we had had that maximum age, and that is not in this agreement. So I just wanted to point that out.
Yes, thank you.
And then we had also taken out some portions of the internship that would not be tweaked.
And Article 15, in drug testing. We're still, yeah, we're still. So we had some discussions on this. We made a couple slight changes with the coloring. So different than past agreed contracts is in the end of anabolic steroid panel critical incidents would be included in this definition. I know that we're just working on some of the clarification on exactly what that panel looks like and what standard that it will be used, just so that when it is implemented, our members will know exactly what is there testing for and all of that. We have no problem with testing for anabolic steroids, but we want our officers using things that they shouldn't be using to begin with, so.
Well, and the other difference, and one of the ones that I know is important to your officers, is that that particular test we're to the point where we don't think it's gonna be a blood draw, it's gonna be a urine sample.
Yes.
Absent something else specifically causing a reasonable suspicion for a drug that isn't covered in, we have a new urine panel that can cover those, that would be for the critical incidents. But absent, evidence missing or some very specific reason to do a blood draw, alcohol would be the other one. It would go to urine for those tests as well, to be less intrusive on the officer.
Yes. Did you have anything else on that?
I don't think so. We are working on, the requests that we had discussed on, kind of, some off-brand things that might come up in a panel, and I think you've talked to.
Yes, ma'am. I think that's the key to it, is just understanding for our officers what this panel includes, since it is something new. Just as a professional athlete will have a list of possible over-the-counter supplements that they can get that would then indicate a positive test. Like Tyler said, the APA is in no way, shape, or form saying here against anabolic steroid testing, but just like professional athletes given a list, these are safe products. We want to make sure that the department is able to provide that to the officers.
Right.
They know.
We're working on getting that for you.
Yes, ma'am.
In fact, I know that they've actually been over there twice to St. David's this week trying to get a move on, but we definitely hope to have more information prior to finalizing the contract, just so that you know exactly what we're doing.
Fantastic. Thank you.
We jump into 18.
We're gonna hold 18 just because it does have some reference to some economic
Okay.
proposals, so we'll hold that.
Okay.
I know we talked some around the economic proposals in
Well,
the subcommittee.
Yeah, that's the only one that we're not really in agreement coming out of the subcommittee anyway. It did have a separate financial component that had not yet been, included in writing it, so.
Right, so
Well, I
we'll
agree.
hold off and we'll
Let's-
go over that when we get to the economic, we'll walk through what we have in there and then the city to. And then we'll go to 21, so 20 is term of the agreement, but we are still working on that one, so we'll get that, but then you have 21 notices, 22 entire agreement, 23 savings clause preemption, and 24 the consolidation of public safety officers into APD, the PSUM officers. There were no changes on our end or your end from what has been in prior contracts, so all of those getting knocked out. We read in subcommittee and even in our first meeting.
I believe so.
Same. So,
We agree.
and I think that's everything that we did subcommittee wise. Again, I just want to thank the city for their work on that.
Thank you, and Chris as well, yeah.
A lot of emails going back and forth, a lot of meetings took place to get that work done, so that we could get through it.
All right, you ready for 16?
Let's do it, Ron.
16, 17, and 19 were the three areas that required that the city and the association reach some agreement, make sure that those sections were non-conflict with the ordinance. So everyone's looked at it, reviewed it, and this is kind of, I'll say where we are. The first area was in section 16, Article 16, protected right, section 2 definition. So since we no longer had all the definitions from the prior agreements that were in when we had oversight the contract, we don't have oversight in this contract. But not all the definitions that were in the ordinance required to be here because they had nothing to do with bargaining, they just said, this is a city. We picked those definitions that each side felt needed to be articulated in the contract. First being anonymous complaint. The definition in the contract is verbatim to Prop A. Anonymous complaint, show me the complaint, in which the identity of the complainant is not recorded by the city. You mean to go through these and you go back if you want, where you want?
I'll chime in when if I need to chime in. Okay, go ahead.
So the second is the definition of complaint. And the complaint definition is verbatim from A. Complaint shall mean a verbal or written communication alleging that an officer acted improperly and may have violated any law, policy, rule, or agreement governing the actions of any police officer while employed in the employ of the Austin Police Department. That's verbatim from the act. Complaint done is verbatim from the proposition, from the ordinance. Complainant shall mean any person who submits a complaint. However, that definition is in conflict with section 143(3)(12), which is the Bill of Rights for officers in Austin, Fort Worth. That in Austin and Fort Worth, they're covered by that statute. So we agree that definition does not include, we preempted that. So the definition that's in the ordinance will be the definition in the contract. So, so we would said, whatever the is complaint, shall mean any person who submits a complaint. That would be it. The second was critical incident. And
Can we hold on just a second? The last sentence in complainant is very innocuous to us who knows exactly what it means. But I think once this document becomes public, I think a lot of the public is not gonna understand what that last sentence means regarding the referral from the department. Meaning it doesn't mean an officer. Can you go through that a little bit?
back, well, I know I see it, but I'd have to go back and pull. Is that,
So,
it
So
seems like that's
it's coming from if it's an internal complaint, so a supervisor, sergeant, lieutenant, commander sees something from some review that they're doing, whether it's or the fourth group that's sent back to them from the fourth review unit, and they see it, and they see that there's a policy violation, when they send that back to internal affairs as a complaint, they're not a complainant under this statute, under this definition. It's an internal process that is a little bit different than an external complaint coming from a citizen who had bad interaction with an officer.
well, and the city agrees with this definition, and I just want to state how it reads for the public consumption, because I think this might cause some consternation if they really don't understand it. It says complainant does not include the department designee in the case of an administrative referral initiated by the department. This is not a loophole trying to get around anonymous complaints by officers. This is talking about the administrative referral within the department by the designee of the department who does that. So I just want to make that clear for the public, because I don't want any big red flags coming out for something that's completely unintentional. This is something the city agrees with your language on, and we're good.
it just, yeah. Inside the police department, they're not a complaint, they're taking the referral and sending it
Exactly.
out. Somebody else may be.
Yeah, because a named complainant, so someone who doesn't go in the anonymous complaint category, that's someone that IA would call in for attention for an interview. If a sergeant files something, they may or may not be called in because they filed a little report, and then the IA then calls in all the officers and witnesses that were through the event. This is someone that's probably would just doing a review, caught something, it's like, hey, we need to look into this. And then
Right.
they investigate those that were actually involved. Sergeant may not have actually been involved, and that's why they're not a complainant.
Right. But it's really easy for you guys to know exactly what this
Exactly, yeah.
means
But
and not for
The public may not
to-
understand exactly. So
Right.
Happy to make the clarification.
No, I appreciate that.
physical incident is not in Prop A. But it is referred to, is to drug testing, and I think it may be referred to in 143. It's not in Prop A.
It's in the, review, for the officer's review of the file as well.
So, but we're okay. It is, it says what it is. I think there is some different language you have in D3 that whatever the statute is about what's a weapon, a firearm.
A firearm. Yes, so what we will be sending to y'all as City of Austin language proposal would be that firearm definition will be consistent with current APD policy.
Yes,
And this definition of critical incident is exactly what is in APD policy, and
Yes.
with that little clarification in there from what the original draft was.
But yeah, for public edification and your members' edification, it changes nothing in your current policy or practice.
yes. All right. The next definition is disciplinary action. This is not in Prop A, but it's a definition the association wanted because throughout the contract, the term disciplinary action is used. Disciplinary action means a disciplinary suspension, indefinite suspension, demotion, and rank, or any combination of these actions. Disciplinary action is an act in which the chief can suspend, terminate, or demote the officer that he takes disciplinary action, or she in this case. So the second definition, discipline, which is in Prop A, means a field note, disciplinary suspension, indefinite suspension, demotion, uncompensated duty, written or oral reprimand, education-based discipline, or any combination of these. That definition is out of Prop A and is not in conflict with disciplinary action. The chief can do, these are all discipline, the chief can issue all of those disciplines. They're not appealable. So disciplinary action, he can issue a field note. And well, some of these in here are, okay, they're just separate. So the field note, uncompensated duty, written or oral reprimand, education-based discipline. The chief can issue those. There's no right of appeal, there are no time limits on it. Chief, the officer, he can say, you're going to the training program, or I'm giving you a written or oral reprimand, or a field note, which can be negative or positive, all classified as discipline. They just don't come with a loss of pay. So both definitions are there. Don't believe that they're in conflict. So if you ask for someone's disciplinary file, you would get all of the things that are listed in Prop A. So I want to see your discipline. So it's in there. It's just things of which they can issue, you don't have right to appeal. Evidence, this is, evidence is not in Prop A, is it? I think the city, it's not in Prop A, but for some reason, the city wanted evidence, means statements, records, reports, records, recordings, documents, computer data, text, graphics, videotape, photograph, and other changeable forms of information, including a complaint. We don't have any objection to it, just not. Investigation is in Prop A, and the definition from the ordinance is investigation means the collection and review of evidence related to a complaint or incident or an administrative review of officer conduct. Because the definition in the ordinance conflicts with the definition slightly different in chapter 143, 312. The association has agreed to preempt 312 and operate on the definition that's in the ordinance. Statement is not in Prop A. But the city wanted the definition. We don't have any problems with it. A statement means a communication, oral or written, setting forth particulars or facts regarding the alleged misconduct under investigation. So those are the definitions. Some are between the parties, some, if they're in the ordinance, they're in there. or two are preempted because they require.
That is definitely one of the buckets. We have some discussion we need to do on our side, for what, I believe anonymous complaints. But otherwise, it appears that we are very much on the same page when it comes to definitions. And I want to back up a little bit and just, absolutely commend y'all for being very receptive, being open, looking for paths to find a way in these 4 buckets that we're talking about. And then the informative meetings that we've had about G-file, et cetera, the last time we met. So, y'all coming this far is very encouraging, and we look forward to the rest of your presentation on this.
And can we take just a moment to explain the 4 buckets a little bit more? Because I think, we're deep into all of this and get it, but I think a lot of people from the outside are not. And they don't understand why we only have certain definitions in the contract when there's other definitions of prompt pay. And I think from the beginning, both sides have come from the perspective that the meet and confer agreement is in order to preempt 143 of the Texas Local Government Code when necessary. And aside from that, there's an ordinance, which is over here, that isn't part of the agreement. And both sides are not, we understand that the association is not saying, we agree to Prop A in that manner. But what you're coming around and looking at are the things which must be preempted under 143, and those are the issues that you're addressing to us. So I think it's a little harder for the public to understand, and I hope they will, but I don't know if you want to explain that any differently.
No, I think your explanation is exactly and simply on, which is we're referring to buckets, and those are the topic areas where in order to achieve compliance with the voters' Prop A initiative, we have to contractually change those parts of the law. So that's our mutual determination that with respect to these things, the law is different. We have the authority under Chapter 143 and the bargaining statute to make modifications to those laws, and we're changing the things that need to be changed. And the things that don't need to be changed, they're either already in the ordinance or they're separately in the law, and we don't have to put them. So that's
We don't need the definition of officer, office, city of Austin,
Chief of police.
chief of police. There's no disagreement. Secondly, if we don't address the ordinance stands for whatever the ordinance stands for. It doesn't require us, just another law out there with these words in it. Anything else on that?
A definition is fine.
No. Right. That testimony, of course, I know it's not in Prop A, but we've had prior language that there's no subpoena power from the manager or the officer to appear in any third party outside the police department forum, and be compelled to give testimony, does not apply to an independent investigation ordered by the city manager and chief. So that power, we're agreeing that if the city, as we discussed earlier, hires an independent investigation of the police department, then chief and our officers can respond and answer to that. So basically, officers are subject to the orders and subpoenas to appear and provide testimony or evidence in such investigation or hearing that are set up under independent investigation. And this is complicated in a very narrow world. Public employees, police officers in particular, can be compelled to testify against their own self-interest. They cannot take the Fifth Amendment unless they're going to be fired. But on administrative rules for investigations, in the police chief orders you to show up at internal affairs, you're given an order to write a statement about this event. You refuse to do that, you'd be fired for insubordination. Longer than Larry and I have been for police, that's always been So, but in that environment, protected by court cases, and it can be debated, but there's a deal called the guarantee. It says, I can order you to testify and write something down that's against your own self-interest. But for that, I cannot use it in a criminal investigation. Because if you're in the CID or the FBI, you could take the fifth. But here, I'm sitting before the employer on a rule violation. These aren't criminals, rule violation. And when the chief orders me to get it, and I say, okay, under orders, condition of employment, and then there's a statement that says, I've ordered you to do this roughly, and when you do this, this is information that's not open, be used against you later by the district attorney or prosecutor, criminal. CID, as far as I know, doesn't get those files. It's not, they're separate, the police department. Internal affairs, they have their own world. Now, CID may show up later in interview you based on this, if it involves potential, but you have the right to an attorney and the right to take the Fifth Amendment. So what we have here, we recognize, and this is just stating what we already agree on, because we ordered to go in Texas, nowhere, there's only a few places in the United States where an officer can be subpoenaed to some outside agency or group and forced to give testimony against their own self-interest. There's no one there that can give you a guarantee warning. The DA could be in the audience and you can be ordered to give a statement. You got no guarantee. That statement could get you charged. Now, you may get charged anyway, but not based upon what you confessed to. You were not allowed to give the Fifth Amendment. So, withheld testimony has been in the contract, or at least it was in the red line. I didn't go back further. So, this is the language. You don't think it requires any Prop A? Nothing in Prop A about subpoenas or compelling officers to testify that I'm aware of. So, that's our language, been the language, and we're okay with it. We think it provides the officer fundamental rights. Okay.
Okay, and so what I'm hearing is obviously the insistence on the Garrity protections for the officer or compelled testimony ordered by the chief in an IAD. An IAD construct, that's what I'm hearing. And then if an agent, defined under 153.312, which is defined as a city of, an agent of the city. This is what I'm hearing, just recapping what you're telling me. That if an agent of the city or an investigator of the city is within the confines of IAD, they also get to ask questions and the chief has to order them to ask questions because they are Garrity protected.
Well, let's use better words. We're not arguing they can be there because we don't control it. Whether they get to ask questions or not, that's up to the chief. And I'm saying we're not stopping that. So if the chief says, investigator A, go ahead and answer questions. I don't know how, because there's going to be an order coming with it, either from the ID sergeant or coming down the line saying, you're here, you're compelled to give testimony. Somebody asks a question. If you're under order to testify, we believe you can do it. You can make what other later grievances you have, but we're not arguing that. That's all inside, and the department's giving you the guarantee. That statement you're giving, the chief is saying, that's a protected statement because I'm ordering you to do it. Now, that person who's out there cannot be outside of that system because that person on their own has no authority. Nobody works for that person, they work for the chief as far as who's in charge. Asking questions is fine. They're gonna do it, they're gonna do it. Right now, I don't know.
Asking questions and then the chief ordering them to answer in that IAD construct.
Yes.
Is also something y'all agree.
Well, I agree he can do it. Okay.
I'm trying to
Yeah,
understand.
I'm not agreeing that anybody ought to be there, but the law says they can't. The law says they can have a government agent, that's in the law. You stay within the law and don't violate the protected rights of the officer, then that chief's gonna control those decisions.
Don't think I have any other questions. Any other questions for me?
May I step
I
down?
have a question. I do.
And this witness be excused.
No, I do.
Step to the door, go ahead.
So under 312, it's, an agent of the municipality, can be an investigator. Is their right to ask questions and interrogate changed by our definition? And you probably want to go back and look at this before answering, but I want you to look at the definition of investigation that we have here and the fact that it preempts 312. Does that in any way change an investigator's authority to interrogate an officer under 312? And I don't expect an answer, but I literally it happens to be on my screen at the same time while I'm looking at compelled testimony because it's right above it.
Well, the definition of investigation is the collection and review of evidence related to a complaint or incident. All we preempted, and I left 312 in the other room,
I did too.
just has a different, slightly different definition that would not have been exactly the same as the ordinance. But none of this addresses power of any investigator. They have whatever authority the law gives them. I don't know that that's in front of it.
No, it's in 312. My question is more, does the preemption of 312 in the definition of investigation itself preclude any previously granted 312 rights of the investigator if they're duly authorized? Like,
Look,
we need to look at it as well. It's just coming to me as we're looking at it here.
I have a printout of 312. 312 is a different number for the investigator language. It's not in the word investigation, isn't it?
It's the definition of investigator is also in 312. And right.
But it's a different number.
It's in 143, 312, as is the investigator's right to
What's
interrogate.
subchapter?
143, 312, subchapter. It is.
Oh,
We're not preempting all of 312.
it's right, that is my question. Do we need to be more careful when we're preempting 312 for investigation to make sure that we are only preempting it in relation to? Let's look at that. Do you know what I mean?
I'm using your language, but we use investigation, just that word, if you want the subchapter in there. But the chapter for that in complaint or specific subchapter. And then the right to have the city have an investigator is in another subchapter. We're not.
Same
It's
subchapter.
same subchapter.
143, 112, B.
But B.
And investigation and investigator are in B.
And then C is the right to interrogate.
But they're not the same.
They're not the same. And C
One
has.
43,312, B 2 is preempted. And 143, B 1 is preempted. Nothing else is preempted.
Right, and that's my question. I think we need to look just right above compelled testimony to those, and when we are preempting them in our language, we need to parenthetically say A or B.
It doesn't bother me, because we're only preempting that subsection.
That's what I thought your intent was, and I
No.
apologize for the convoluted way I asked the question, but I just had it on the screen at the same
Your
time.
other Bill of
And
Rights
it
in
occurred to me we need more
312, we're not
specific.
preempting.
More specific.
Okay. Okay,
Yeah, the dilemma here is just that it's a very long section, you know. We're just focusing on what are we changing, what are we.
If you want to narrow it, go ahead. Look at it. All right, are you ready? All right, let's go to section 4, maintenance of record. And for people that, it's a G file. Next two are basically things of which 99% of the public and the police don't really know what this means. It's much to do about nothing. But I guess if you believe it, it's perception is reality. So what we have is after the effective date of this agreement, complaints that occur after that date, there will not be a G file. So whatever comes in your personnel would be open to the public. In the G file, and I'm not looking at the statute, but basically, are things of which there was no evidence of misconduct, no just cause to discipline you, or unfounded and a series of things. So it's material of which a complaint is made, but there's no foundation to it, no discipline taken. That's been in the G. So groups of people have gotten all wound up thinking there's some magic there. There isn't really. It's more in about false light and revealing things about people that people make allegations, and not just against anybody, that are not true. But we're fine to comply with it after the effective date of this agreement. So then, my language to the city, well, the second part is for complaints of alleged misconduct which occurred prior to the effective date of this agreement, the department will follow 143-089 as they do today. So if the incident occurred 2 months ago, and then we adopt a new contract, that would be treated as it is today. If the incident occurred the day after we sign a new contract, it'll be treated as a public record. It's not complicated to me. The language the city had put out there was just a bunch of verbiage about identifying what the practice is. It doesn't matter. That language is all in 143-089, we'll just follow 143-089. It's all about clear demarcation when this process starts. That won't either date of the incident, or it's treated as is today. After, it's treated under the new guidelines.
Listening to what you said, we're basically on the same page, from the date of the agreement and for complaints that occur after the agreement. And the last little bit, when I'm looking at your wording for how complaints are handled prior to the effective date of the agreement, the city is in agreement with that concept. It looks like there are some word differences, as you said, verbiage that we need to get past. But in terms of the concept of eliminating the confidentiality of the G file, I am hearing that effective upon the date of this agreement, that the confidentiality of the G file shall no longer be, except for complaints prior to.
We're not arguing about what happens after the day of the contract. That language nobody's arguing with. That would be the order. So what happens prior to coming under the contract? The language that previously put out created confusion about it being after somebody made a determination of whether it's in the G or not. That doesn't need to be in there.
Because it's in the statute.
It's not in the ordinance.
Yeah, right, it's in the statute.
It is.
It's in 149.
But
What you said.
But you placed it where it's right after, occurred before, then when the city makes a determination, it makes it look, well, maybe there's two different periods. If it happened before, that's all we have to say. We'll operate under the law.
In effect then, right.
In effect then, we are saying the same thing.
Okay.
It's just the words that got to get right on the page.
We await your
Yeah,
wisdom.
and the challenge for, anybody that hadn't dealt with this a lot is that we have the date of the incident, then we have the date of the complaint, and those things will get you confused.
They won't be confused under this. You and I have talked about it. 100 lawyers have looked at it. Association very bright line. The date of the incident. Do you wander in 6 months later? Come on in, but it'll be treated under the old law. And if it happens one day after we sign it, and they don't come in for 6 months, it's now public.
And just to recap briefly on our last meeting when we had that presentation about the G file and to alleviate any concerns that private information, social security numbers or personal cell phones, emails, all of that stuff will remain confidential for already in existence law under the Texas Public Information Act, right? And I know you're about to get to the next step because in exchange for the removal of the confidentiality of the G file, we are providing notice on 2 occasions, which you're about to walk through.
Yes, yes, and the trade-off is currently, and having listened to it here and bargaining for work and having the woman that is a lawyer or all that, you know, it's complicated. They get 600-700 requests, traffic reports and along that. And so they got all these people looking to make sure. But under Texas Government Code, I believe, 552, the state outlines stuff, and there's lots of confidential material not allowed to be released, not just on like city council members, trustees, school board. There's hundreds of things that the government has said you cannot release that material. Those would still all be protected, but because we can't change them. So in the second part, what we added is when the city gets a request, and this is not an incident report, traffic report, none of that's our business. But if someone requests the personnel file, which would normally be in 143-089, that the association would be given notice that a request has been made and the association would then get a written copy of the request. And that allows the association to notify the officers that the personnel file has been requested. They may not care, but if they do, well, then we should have notice. And the second notice is once the city has reviewed it and decided to release the materials, association would just be notified. Way to change it, the city has responsibility not to release confidential information for criminal penalty. But the association would at least know that that material has. So that was the trade-off for the new system, is that we now have no knowledge of what's going in, what's going out. People getting your file, we have no way to look or check. See, we're going to try. It may be overwhelming. It may not be. But the city, when they get the material, according to the lawyers here, they send out to the people that have that material. The police chief, go to the recruiting, go over it. Mostly it's IED. They give us the files that have been requested. They then look and see is any of this material currently, is any of it a G-file material, or if it's not, it's public. So I think it's a good trade-off, and it's probably the second, call it the bucket, the second bucket was switching to this system, and then for that trade-off, the association would be involved, at least knowing when people.
Because under the current system, a TPIA request comes in for an officer's file, there is no notice in any way, shape, or form, but in exchange for the G file.
Yeah.
The membership or the association will get notice on 2 occasions. Once when it comes in, if it's related to their personnel file, and then 2 if it's released.
Yes.
Prior to its release.
Prior to its release.
Under Section 5 investigative process, I think this is old language which was more geared originally to the civilian review panel. But this language, you've got what we've got. I don't know if it requires anything different. But if this department gets a request from one of these outside groups, forums, the officer and representative has a period of time, they can review the evidence gathered and obtained during the investigation. And that's it, then they don't control doing it, the department, whatever the law says you have to supply, that's fine, but you're gonna release, these are internal affairs investigations. You're gonna release those files, the officer has a right to look at them. Yes. That's about it.
Right, and this subsection G, it was already language from the 2018 contract.
Yeah.
We basically cleaned it up so that it would fit what our current objectives were. But otherwise, the right that the officers have
Yes.
still stays the same.
Yes. Now, I added a J, which is our proposal, and actually a couple of places in the agreement. It said representative or representatives. We didn't want there to be a belief that, we're going to have 10 people show up. We recognize it generally means the officer, representative from the association or the attorney or both. But I went in and just put an explanation. If there's more than that, will be occasions where they may bring an additional rep who is being trained to work as a representative officer when they go to disciplinary review hearing. So I don't look for that to be very common, but I didn't want to go back in and put representative. There'll be no confusion. It's just a lawyer and a union representative, unless there's somebody they're bringing because they're training to do this. They're called peer reps for work. You can bring someone in training. They have officers who work with the department to go with the officer. So I was just trying to clarify, you can't bring.
So what I'm hearing is, so I did notice that in some sections in the current language of the contract, it allows for the association president or an attorney, or both, right? And you added plurals to include that. We did have a discussion internally about how they train their IA and their video being able to be utilized for those training purposes. We can have further conversations about that. But we'll take a look at this language that you.
Go down to the section 6, dismissal review hearings. This is an officer's louder hearing. Period where, yes, you get a chance to go before the chief and make your case or they issue discipline, not the hearing. You allow you, the law allows you to make your argument. So the only difference was in C, city had added some language. However, probationary officers are excluded from the coverage of Article 17 and cannot file a grievance pursuant to Article 19 regarding disciplinary reasons. That doesn't need to be in there. It's already in the definition. You'll have it over in 17 and 19. It didn't need to be restated. Probationary officer not have any rights to appeal an intimate worker during their probation. Probationary officer is covered by the contract for anything other than disciplinary action. So I don't think that language needs to be there. I struck it. But if there's going to be a disciplinary review hearing and the person's on probation, I would imagine if they're getting called in, that they're probably going to be terminated. Because there's really, you're either here or you're not, they don't give you suspension. But the association has the right to represent them as they would any officer, because they're members of the association, are covered by the bargaining unit. So I didn't feel like we need to restate, we're already stating 3 other times.
We do have this language in various locations. What I'm hearing though, it sounds like we're on the same page about probationary employees. The city is willing to provide notice, but not expand what's already current probationary reps currently have, right? We'll take a look and see if we can.
Yeah,
We did take a look to try to not have it all over the place and only need it where it's necessary, so we'll do that.
yeah, I think where we initially had put it in is every new place where you had put the notice in.
Yeah.
So we didn't want the new notice in a contract to probationary officers look like it was expanding other rights except for the notice. So that's why we put it there, but I think we're hearing what you're saying, I think we're looking at maybe just 17 and 19 for the specifics, but we'll look at that a little more closely and we can get back with you on those concerns.
In section 7, dismissal review deliberations. You want to talk about that? The city struck it. You have it, but we don't, I know we struck it. It had some connection to the previous contracts about OPO. But we think it stands on its own. And we'd be curious why you struck it. You want to comment on why we think it already in the contract.
Yeah, I think when we looked at it, we looked at it, so there's A, B, and C listed in there. B, we have, that's already, that doesn't have to be in the contract, the chief is the one that sets that. Everything else anyway, so that language doesn't have to be in there. The one that we do want and in the contract is A, where that once they go in on this dismissal review deliberation, once they have the officer in there and they've talked with them, the officers and their representatives step out. This part says that the only people that can be in there is the chain of command up to the chief while they're doing their deliberation to determine what the chief is going to hand out is discipline, if any. And that it's only those people that are in there, and then when the officer is brought back in, obviously they're going to, but that is some language that we think that deliberation time should be limited to just the chain of command, provide, as it has in the past, to provide their recommendations to the chief, who then the chief obviously.
Let me tell you our intent here, because I'm not sure. I think we need to go back to the command staff and discuss this with them. Where we were coming from is when this had been initially brought up during past negotiations in relation to OPO, it was that OPO wanted to be in the room for deliberations. And basically the conversations went, well, if chain of command's not even in there for deliberations, if OPO is going to be in there, chain of command is going to be in there. So it's either both or neither. And that was our recollection of the conversation. So when OPO was taken out of the contract, our answer was, well, then if it's not current practice that they're currently in there, then none of this needs to be in here. So I think we need to talk to our command staff again and see current practice as to whether chain of command is in there or not. And if that's a new practice that you're requesting. Because to us, it was a new practice, because in the past, it was both or none. And that was just our history of bargaining throughout the years and where that was coming from. So it wasn't I could care less if chain of command is in there during deliberations, but it was more just a historical memory of how this had come about. So let us chat with our.
And we also can't have language that would prevent chief's legal advisor.
Yeah.
And that's an attorney from the city attorney's office may remain in the hearings.
Yeah, it wasn't,
I didn't say no.
yeah, it wasn't meant
I
to
know y'all
be-
weren't trying to keep that out.
Yes, no, thank you for pointing out, thank you.
Yeah, it wasn't meant as an exclusionary tactic for others. It was, are we adding people in? That's how we saw it. So let us rediscuss that internally.
I mean, if you'll go to section 8, public release of records and misuse of information. There's some old language in there, subsection C, and I struck that language. Really am paying close attention to it. This carves out a very narrow definition that an officer suspected of alleged violation of 8D, which is retaliation, threat by an officer or an individual at the direction of the officer against the officer, the term for his statement is strictly prohibited. A sustained violation of this section may result in temporary indefinite suspension. We're not arguing. You do that, what we are arguing is having language that says for that sole violation, not anything else, all the department has to prove it's true and it's open. And that leaves out all of what it normally be is, I'd like to tell my side of the story. This isn't correct. It may be true, but, and that's all disciplinary hearings are about disparate treatment and other factors. The fact that it's true may or may not, now, you may still get fired. I'm not arguing that firing, they can go to arbitration. I'm arguing is, you can't have this very narrow deal of which you win with the other side cannot even put in their explanation or disparate or fact situation that the arbitrator can weigh. We're okay with the language. I'm not okay with having language that carves out this little one charge. Or that the employer, well, obviously something's true or they wouldn't have charged you, but that ain't the whole story. So I struck this was from an old contract and I want it in there.
It is from an old or it's from the 2018 contract. We have a note in here to speak with our internal team about this, so I thank you for that clarification. We're gonna go back and talk with our team on it.
So just to be clear, they can be fined. And it can go to arbitrator, but the whole story will be laid out.
What I'm hearing is what you're seeking is the just cause principle just cause includes determining whether the conduct is true and then the reasonableness.
That's
Well, it's limiting the remedy of the arbitrator.
Right.
I mean.
Yeah.
I mean, I think we hear your issue and we will discuss it. I don't know, I will come out on it, but we were just talking about that.
pretty
yesterday.
comfortable, you're going to come out on our side.
It's probably.
Oh, right, sure, you mean
It's
lunch.
probably a very important issue. I negotiated and got a concession from him years ago, and now you're trying to take it back.
Well, I know I didn't do it to it, so I would suspect you could fool an old sergeant from Houston. Life sergeant. Section 9. This is city language. I don't have any. You can't disrupt the process.
Yeah, that's what we were looking for. The old language used to say that so long as the attorney complied with city protocol, and what is that, right? So we just, this is
It's
what.
what we do anyway, we sit in these, and we don't say anything.
It's not here.
We're not saying anything with.
No, we're not disagreeing, we're okay with the language. I won't say anything about 12, but I'm agreeing to it. Let's go to Article 17, if you would, and there's really one change. And that's in Section 8. And this is the third bucket, if we're having buckets. And this is called the 180-day rule or statute of limitations. Another area of which a lot of people have opinions of which they don't know what they're talking about because they don't understand it's very narrow, lives in this very tiny world. But just about everything out there in the criminal all have statutes of limitations. So this is a statutory statute of limitations in 143 Civil Service Law. It's been in the law. Could have been in the original law in 47. Larry was there. 47. Certainly Larry doesn't remember. It's been in the law when I came 55 years ago. It was there. So in the mid-80s.
I think Louis Aber knows the answer.
Lewis or Donald Dale?
Yes, sir. Right. He had his birthday last week.
Did he?
Yeah.
Oh, he's still alive. He was still partying, like 94 years old.
Yep.
And he goes by Abear, not he.
Mhm.
He's a real case. And the statutory definition in the ordinance, it required that the chief have 365 days of which to make a decision to charge someone with an administrative violation. These are Administrative violation, nothing to do with criminal. That's all in another law, and the chief does whatever law, they can arrest you whenever they think they've done the proper. Oh, but if you're charged, if he's looking at a rule, someone complains on and off. Currently in the law, the chief has 180 days, 6 months from the date of the incident to bring an administrative charge against the officer. If they fail to do that, then they cannot bring an administrative charge, but he could, and usually does, they can issue a written reprimand. What you're right. Now, second part of that, added in the 1980s, if the administrative charge against the officer is related to criminal activity, it's not a criminal charge. Let's just say you committed official oppression or you allegedly hit somebody and they complain. Those things, 180 days from discovery. So if somebody comes in 5 years from now and says, yeah, I didn't report it, but this officer struck me, it was wrong, the department can start an investigation then. At the time it starts, when they discover, in this department, assistant chief are hired. So once it comes to them, it starts the farm. And he has, here, he's saying he would be, she, the chief, she has 180 days from discovery. So that's been the law, at least since the mid-80s. So to figure out how to be in compliance with the ordinance, the association has agreed. It's bifurcated here in that prior, any alleged misconduct which occurred after the date the department adopts the contract, chief has 365 days to discover, to file a charge. That complies with the ordinance. The caveat is after the effective date, if the incident occurred prior to the effective date of this agreement, the chief follows the current law. So that part, we agree. So here becomes the difference in the two proposals. And that gets down to the word discipline. The chief retains the authority to discipline officers. And the chief concerns the authority normally would say, take disciplinary action against the officer. Because at this stage, disciplinary action is things of which the chief is on a timeline because the suspension will be loss of pay, termination, or demotion. So in our proposal, it follows what the practice is. Chief can take disciplinary action. The definition of this up in Article 16 from the ordinance is not changed. All that list includes some things of which you can be disciplined on and things of which you can appeal. So this request to put in, the chief has the authority to discipline officers. I could live with that. But then our language would be two parts. Currently in the ordinance, the non-suspendable things, written reprimands, oral education bags, field notes, those have no statute limitation currently in the law, and they have no statutory limitations in the ordinance. 15 years from now, they can give you a field note, they can give you a suspension, they can send you to training. No. So by moving the word discipline over, what's happened is the ordinance, which is open and open-ended on those non-suspension terms, will now be left and restricted to 365 days. And since you have a maximum limit from date of incident, 3 years, 36 months from now, They can't issue a field note, they can't give you education, they can't give you a written reprimand, they can't give you an oral reprimand. And we're not trying to stop that, we're just saying, if people wanna be too cute for their own good, they're gonna basically have less in the contract than they have in the ordinance. Because once you put it there and you say that word means what the definition means, that's the, because there is no limit now the chief cannot issue a remit. Something comes to them, you miss the 365, well, I can't give you a record. So, I just want that to be plain. So, if the association were to agree to use that, even though the chief couldn't suspend you, reprimands don't come with the loss of pay. We want all of them to be appealed. We're gonna move them over there, put them all in there. And this is in a section about appealing. That's the trade.
Understood,
You understand my position?
100%.
There you go. That's all the
We cannot recraft the language of Prop A, and we need to utilize it in contracting. We understand your position and we'll discuss it.
Sure. And we've been duly warned.
Yes.
What?
We've been duly warned.
Duly warrant.
And I didn't even have to raise my voice.
No,
I've been waiting all of that. We've been feeling tickets.
Sorry, Ron.
Well, I had 7 donuts, and I got those kids off my lawn at 4:30, so they doing it. For their parents. All right, you understand our position. Now, part of the trail of the association, agreeing to 365 days was currently in the process, even 180 days. There's no period of which the department will tell officers what's going on with their case. And they're, let's talk about perception versus reality. There are officers that believe they're left sitting out there when they could have known that the charges are dismissed, or you're gonna be suspended, and it's past the point of which they should have made a decision. That's perception. So now, as part of the trade-off is, once we come to the 180 days, then the officer has a right to meet the chief or an assistant chief and get some explanation, reason why that case hasn't been brought to a conclusion. Now, the officer may know that, the officer may not be in a hurry to find out. But if the officer says, look, somebody complained, I'm in a stop sign, y'all been, or let's say I lost time. And it's been sitting out there, I need somebody to make it. What's gonna happen? So, I think the trade-off is the notice requirement, the right to have a union representative go with the member, and the chief or assistant chief explain. They don't have, there's no just cause here, they just have to. This is what's happening, this is witnesses, we're done, whatever. But it does require somebody to at least focus on it, not let it sit out there for 360 days. And that's the trade-off on our end, which is something new that the association will have, which it not had in the past, which would, I believe, help the association.
and we've resolved that, because that's a reasonable request historically. Also for the public, people in this room know this, in prior bargaining sessions, y'all have brought this up even under the old Humming Mamie Hayward. About notice or an opportunity to know what's going on in the investigation.
Sure.
How long they take, whether or not they should take that long. One of the unfortunate aspects in many departments, sometimes it's true, sometimes it's not, is that ironically, a lot of times it's the minor cases and maybe the ones that won't result in discipline end up being pushed to the back of the stack. And so you don't know what's going on with your career for a long period of time because maybe more important cases are getting the attention. But we recognize that doubling the amount of potential, I don't know what's going on time, make this a reasonable request.
All right, let's go to the last one. Oh, down in section 16, there's a small change from chief, from IED lieutenant, or rather traditional ambulance better suited. I didn't have any problem. In section 19, there was some language in the middle, this is access to IED file authority of the civil service commissioner hearing examiner. City struck from the middle of that. Go ahead and tell me why. I'm not arguing with you about this price.
Sure.
Tell me why you felt that was, I told Lane why you felt that.
Right, so originally, when we were looking at section 19 in this particular article, we basically honed in on the reference to G file and struck the whole thing. I understand that y'all wanted to place it back, and then taking a closer look at it, what does need to be in there and what we have been saying all along is that in exchange for these Prop A items, such as the statute of limitations, the G file, the definitions, and when we get to grievances, the due process protections of the members will stay in place. And so in this particular section, it says that if an officer appeals disciplinary action and he requests the IAD file, he or she gets it within 5 business days. So that's back in. We certainly don't want to take that away. The language that we struck in the middle of that paragraph is just, we just don't think it's necessary. It refers to 143, it refers to the G file. But in terms of our intent is to make sure that we aren't taking anything away from what you're already used to.
Well, and the other thing that it really deletes is that these other groups that had been in the contract, such as the CPRP and the OPO, are bound by the confidentiality portions when they do see a G file. Well, we don't have a G file anymore, so that part was unnecessary. But the parts of the officer's rights, we tried to retain.
Yeah, all right. Now,
We made the mistake of leaving you the part that you wanted.
appreciate it. Structure section 20 about probation officers excluded from code of Article 17. Are y'all wanting that in there?
This is part of the overall message that we're hearing from you. It's in many places. Go back and take a look and see where we can limit it in those locations. That's on our agenda.
I'm not arguing what it says, I'm just arguing, I don't like to see the same thing 4 times in a contract. It says verbatim the same, that just opens up somebody.
We are finalizing that. I think where we're gonna be, since it's already in definitions, is for 17, we put it at the bottom of 17, for 19, we put it at the bottom of 19. But for 17, it's just 17, not 17 and 19. For 19, it's just, we just put it in the actual article at the top. But we'll do an action answer with that.
Go to the last one, just 19. I don't think it has to be 19 at all. You can't read this with 19, it's only. It already says it up in the definition. Section R2. Anyway, this is the language, this is the final piece. And it's complicated because the ordinance says union contract, a union contract, and not appeal oversight. Well, I don't think we're not arguing about the ordinance. The ordinance passed, it's an ordinance, about law. But you can't have a vision that gives somebody carte blanche to do as they will. And then every time someone says, well, you can't do that, contract says, do this. Well, I'm Prop A, do it now. So let's agree this language here. Grievances under this agreement may be asserted only as to specific provisions in this agreement. A grievance may not be filed if based on the acts of the city that are within the scope of City Code Chapter 2.2-15 as an effect upon the execution of this agreement and consistent with this agreement. And I guess I'll just do a simple example. You can't breathe whatever the right the city has in the ordinance to do as the law allows. But when they come, simplest deal, if someone comes over under contract as a city agent, that city agent has to follow the guidelines set out in the contract. The right to be there is not being contested, right either in the law or in the order. But if they come and this is what the contract says, can do this, use of protected right, they can't do it and run across those that do as a. And that would be grievous, because that's specific provisions in this agreement. So it says that basically in the opening statement. Of this article in section, if any dispute, claim, or complaint involving interpretation, application, or alleged violation of any provision of this agreement. So we agree, we have the right to grieve things of which we've agreed on in the contract. But can't file this a generic grievance over things of which you have the right to do by law. So when you put them into effect, you know about your business. Or you can't grieve that's outside the contract. But you have to comply with the agreement when you come inside the contract. You don't get to break anything in the contract claiming it's a property right. So I'm okay with this language, which the city has produced and our team has reviewed. We think it says what the ordinance says, and it says what the contract. So, look at the contract, every right to do in the ordinance, as you are to do. And we think this fixes 4 places of which the contract needed to be in compliance with the ordinance. The rest of the ordinance is just out. They didn't need our permission.
I think that's a good summary of that process. One of the reasons we've had these discussions today, specific degree of preemption on some particulars, as part of that same discussion, because things that were not preempting, they stand alone in the law. There's 143 or some other statute. And the things that we've agreed on explicitly. It's just like Prop A says you have to have a 365. Well, we put that in here. We put some other provisions in there with it. And obviously, if we don't give somebody their notice after the 180 days and don't let them meet with the chief, then that's part of the contract you can enforce.
All right. I would like to have everything resolved before we leave today, except economic. I don't want, I'm not talking about something I understand what we disagree. Substantive issue, particularly from that, we agree on what the language is today. Don't want to wait around to next week to hear your answer. You should know the answer today. So we'll break and come back and fix these things, and we're done. Lay out the economics, and we will wait for your review and cost. Right? We don't need any shine because we're right with Jesus. So. You need us over there.
But you probably want lunch, so we will break for lunch and we'll get with our team.
I'm too present to buy lunch. We're cost savings. All right, well, let us know as expeditiously as possible.
Thank you.
You're on.
I'm up.
We could, yeah.
Can be up if you want us to be up. All right. My mouse upstairs, so. bear with me. Just gonna- Start with Article 14. Section 5. What we've done is that very last sentence, it'll just say, prior to any extension of this probationary period, comma, the chief shall provide written notice to the association. However, nothing in the section is intended to imply that an extension of this probationary time period vests any rights under this agreement or in any way changes the at-will status of a cadet or probationary officer, period.
So we deleted the rest.
We deleted the rest of the language.
You'll have, I don't know how many heartburns you need to give me.
Right, I'm gonna give this to you, you'll get a copy of this, I'm just walking through the
This
rights.
gets rid of the grievous language where the confusion that you were concerned about.
This was one of the 4 spots that we had all over the place.
Okay.
And I'm gonna go to 16. Section 2, definitions. Subsection C, complaint.
Just a little louder.
Okay. Article 16, section 2, definitions.
Okay.
Subsection C, definition complaint,
Complaint or complaint?
sorry, complainant.
All right.
And what we did is that in the statute where it used to say 143.312, we put 143.312 B1.
B1?
B1.
Yeah, like we talked about this morning before we looked.
It's all right.
Yeah.
Okay.
Also, same in H, investigation, we added 143.312 B2. Or it used to say 143.312, we added B2.
B6?
B2.
B2. Okay.
For compelled testimony, I'm gonna send you this language, but what we did is after listening to y'all concerns regarding the Garrity warnings, this is how we're gonna propose our language. I'm just gonna read it out loud. Except for the chief's inherent authority to order an officer to appear and provide testimony to an authorized investigator as authorized by the chief or 143.312 and subject to an officer's Garrity rights, there shall be no separate authority granted under this agreement that an officer be ordered to appear before or present evidence to any panel, committee, or commission created by the city. The rest of the language is the same, that we've already previously agreed on. This provision has no application to any independent investigation authorized by the chief of police or the city manager, or to any hearing of an appeal of disciplinary action pursuant to this agreement. And the rest is what we've already agreed on. The beginning part, which I will send to you, is our attempt to address the concerns that we discussed this morning with the specifics of the Garrity warnings and the Garrity rights.
I'm gonna have to see it. So you're adding one sentence to this?
Actually modifying the first sentence.
We are modifying the first sentence.
All right, we'll go ahead and
We'll send it to you.
read, no, just read to me.
Sure. Yeah. Except for the chief's inherent authority to order an officer to appear and provide testimony to an investigator as authorized by the chief or TLGC 143-312 and subject to an officer's guarantee rights, there shall be no separate authority granted under this agreement that an officer be ordered to appear before or present evidence to any panel, committee, or commission created by the city.
I'm gonna have to see it and think about it.
Sure.
What we're trying to do, Ron, and Alex, Chris, is to capture the discussion we had this morning, that the context is in, the Garrity envelope. And that we're talking about authorized investigators. And I think that captures what your concern was. I think if you look at the language and just kind of reflect on what we talked about, I think it gets us there.
Well, I guess my question is, why do you feel this is necessary? Why does this have anything to do with Prop A? If you just want it because you want it, that's another issue. I don't see any connection to Prop A. And you already have whatever authority you have under 312, left that in there. Why do we need separate language about ordering someone to go see somebody who's not a police officer?
So actually within Prop A, it grants OPO the direct authority to determine who the witnesses are that will be investigated under their investigation. So as a protective mechanism for the officer's rights, we were looping that back around to only under the chief's order.
And I'm just telling you, this is the hard push that we had to go through now to get the city attorney's approval for compliance with Prop A. That's what this is about. And when you may not care about that, but we can't do it without it.
Well, I'll go back to my position. You wanna raise it? I don't give a hoot. I don't want anybody going around on issues that cannot be directly determined or in conflict with Prop A, to say, yeah, but I want that, because I might want it.
It's not what it is.
I don't see any direct connection. I'll look like this, well, I won't sign it. Well, then don't sign it. We're not gonna agree that people can be ordered to go see a non-police officer and make them give a statement outside the confines of internal affairs in that room on that day. So this, go report to the OPO office, and I'm telling you, that's what you're asking for, and that's not an A, Prop A. And it's, give me the reading. Because the OPO has no authority over the police chief in 143.
That's correct. What the OPO has under 143-312 is the ability to be designated an investigator. And an investigator has the authority under 312 to interrogate an officer. So in Prop A, it grants the OPO, the director of OPO, the authority to determine
Tell me where you're at.
2-15-3B5.
2:15:3.
3B5. Very last phrase there. Well, the whole thing, participate in investigations of officer conduct, including those stemming from anonymous complaints, with the right to gather evidence and directly interview witnesses as determined by the director. So Prop A gives the director the authority to determine which witnesses are questioned. We were actually being more protected than Prop A while still being in compliance with it by making that run through the chief's direct order.
And with the Garrity protection.
This says they can participate.
And directly interview as determined by the director.
Investigate officer conduct. Participate in, which we're not arguing. Including those stemming from anonymous, we're not arguing. With the right to gather evidence, directly interview witnesses as determined by the, interview any witness you want. But you don't have the right to order a policeman. This does not say that. Does not say that.
We'll belong to D then. We'll belong to D then.
I can't to D. All right. D.
So that in conjunction with D, where the director and their designee shall have direct access without hindrance to relevant department personnel for the purposes of pursuing city's police oversight policy.
That's records,
So those
that's records, not personnel,
relevant department personnel and departmental records.
records, departmental personnel.
Personnel
Personnel and record.
and
They,
records.
they can have, but they can't order to give a statement, they
So-
can't be ordered to go over there.
So Ron, what we're telling you is to get the city attorney to approve this. This is how this is being determined.
I'm gonna step outside a minute, it's all bullshit, and you know it.
It's attention. So you have it, so I'd like you to take a look. We still believe that this is where you need to go. This is part of it.
Okay, so you said that language, oh, that's, so, is there any further on that issue that you guys had?
Compelled testimony.
Was what it was.
There's more in throughout the contract, but the compelled testimony
The compelled testimony.
is done.
Okay, if you guys want to work through the rest of the Prop A things that we discussed first, and then we'll take a little adjournment to discuss that and read through until we actually see the language. It's hard to know
Yeah,
where we're at.
it's in your email box now.
So we'll work through the rest of it. That way, in case there's anything else we need to discuss, we can take a little break, discuss all of it, and then move from there.
Okay, just so you know, this room has a hard stop on it. So there's a meeting here at 5.
We'll be done by, make sure you.
For section 4, the maintenance of records, we are basically in agreement when it comes to the non-confidentiality of the G file. All we're really talking about now is what happens prior to the effective date of the contract. So in the language that I sent over, it's a bit of a combination from Ron's language where it just refers to A and G. We added in language, so now it reads, for complaints of alleged misconduct that occurred prior to the effective date of this agreement, the controlling date for file placement of such letter, memorandum, or document will be pursuant to TLGC 143-089 A and G. Kind of made it less wordy than what it was originally.
And just capture what we said at the table. And just so the public all understands what that's about, we have a current standard that's being applied under A and G with respect to conduct that, predates the agreement that we're making. That rule stays in place. Future, as you talked about.
And Article 16, Section 5G. We edited there to say a panel, committee, or commission created by the city. I think it had a forum originally in there. We took out forum and just said panel, committee, or commission created by the city. And for dismissal review hearings, we had language in there that previously said at the very, very last sentence, included in this section are meetings concerning officers on probation that the department has identified as needing to separate from the department for any reason. And notice would be provided to those probationary officers if they were going to go to a DRH. We had language in there about probationary officers being excluded from the coverage of 17 and 19. And we listened to your comments that we don't need it in multiple places. What we changed in the last sentence here is officers on probation that the department has identified as needing to separate from the department for any reason. However, without expanding any probationary officer rights under this agreement. I don't know if that does it for you. But in an attempt to meet you in your concerns, so it's not all over the contract. Dismissal review deliberations, we understand your need there for wanting that first paragraph in A. You'll see in our proposal that since we've eliminated B and C, that's already status quo there. We just combined it into one sentence. Section 8C, we are fine with striking C. Section 9, there's no issues there. Article 17 is the statute of limitations. we will go ahead and strike that last line, leaving the verbatim language of Prop A, which means that officers will be able to appeal anything that's defined as discipline, and there is a statute of limitations for anything that is defined as discipline.
So I do want to say this. We're prepared to do that. We're prepared to do that in order to make this deal. I don't think it's a good deal. I don't think it's a good deal for APA or for CLEAT or for the city. And so I'd like us to continue to think that's the way we need to do it.
You understand your position?
Well, I mean, we both admitted across the table that it doesn't make a whole lot of sense to have a statute of limitations on appeal covered. Or, to appeal a limited other man. But
But you're
we're
not,
willing to do it if that's the way it needs to be.
you're not required to.
Right.
You've chosen
I
to
understand.
limit yourself.
I understand. I'm trying to not argue with you any further if that's what it takes.
I understand.
Article 16 mediation.
Here, where?
Article 16, I'm sorry, Article 17, Section 16. mediation.
Okay,
I don't think there's a fundamental difference there. We struck that last line because it had to do with the timing. So originally, the language read that a mediation for minor policy violations, and let me just be clear, this particular section is for minor policy like violations that include rudeness, right? And before, the prior language used to be that mediation could be offered at the initial time of the complaint. Y'all's request that it be for any time. And so the very last line had to do with the initial filing of the complaint. And since it's going to be at any time, there might be an investigation already underway. So that's the reason we struck that last line. If there's any heartburn over that, we'll listen to you, but it's just to make that whole section make sense, since mediation would now be offered at any time. Section 19, I think we're good there. We added section 20 here. Probationary officers are excluded from the coverage of 17. So it's just 17 and 17, and it's just 19 and 19 in our attempt to eliminate all the many places that it was.
well, in 17, are you talking about 19? Let me go down.
Yeah, so section 20, it says probationary officers are excluded from the coverage of Article 17. That's the one place where we're gonna put this here. And then in 19, we're just gonna put it in 19.
What are you gonna put in 19?
In Article 19, it'll just say probationary officers are excluded from the coverage of Article 19.
But they can't, there are no disciplinary action appeals in 19.
Agreed, but it's so that way, they don't get to appeal discipline, but not use the grievance to,
It's not in 19. It's like saying you can't buy an elephant. Well, let's just put it in 19. It's nothing to do with buying an elephant.
what we're trying to clarify. is
No,
that-
you're not clarifying. You're trying to put something in that's not needed. It already says that in the definition. You already have it in 17, which is applicable, or in 60, it's applicable. But down in 19, there are no grievances in 19. It's only contract administration.
Right,
So,
but in the event that,
in the event of what?
a disciplinary action is trying to be attacked via the Article 19 grievance language, that's what we're trying to avoid there.
Understand.
So I'm skipping 18, I'm jumping to 19. We're in agreement with B. I just explained C. C is probationary officers cannot file grievances pursuant to Article 19 regarding disciplinary actions. This was our way of trying to put it in a single spot. We'll listen to you as to how you prefer that be in the contract, but what I am hearing is we're on the same page as to what it means to be a probationary officer.
So we have a definition that defines, then we come back and we stick it in two or three more spots. Yet it does nothing to do Vice Mayor employees can file a grievance, understand? Nobody can file a disciplinary grievance. In 19, there's no grievance for that. So I don't like just sticking stuff there that doesn't even go in that article. I'm okay, in 17, you can be clear, they don't have a right to appeal, they're at-will employees, fine. How do you feel the need to put it in 19, when nobody, not a single officer, can come to the union and say, I got fired, I want to file a contract grievance?
I understand your point.
So,
So, any other?
That is also property stuff, the leave that covered everything and maybe have another conversation about compelled testimony. But is there anything that I missed?
I think that's all the prop A stuff, so if we can just take a break and so we can read through and discuss a few things and then let you know.
Send that to them.
I just,
Yeah, no, which is fine, I just find it might be easier to just.
that,
Yeah.
You check your email?
Yes, just got it right now.
All right. I'll restate our position. There is nothing in the ordinance that matches with what the undefinable sentence the city gave. So we looked at the ordinance. We looked at the compelled testimony. I will say, this language has been on the table for about 6 months. And the city has not made, well, one counter, and we accepted it. All that time, until the last days of argument, somebody who hadn't been at this table decide, I gotta have these new words. But I only think that there's bad motives. So we're gonna restate what you said within the confines of which we can agree to. It will, where you stop testimony to end, we said a sworn internal affairs investigator or an investigator pursuant to 312B3, which is the city investigator, and within the confines of an internal affairs investigation. That's what we've agreed to. That's what we have here. And you're there, it's in the police department, and they can be, we've already said they can be, and the chief can already testify. If you're trying to get some magic power to some civilian, because those investigators are not police officers, they have no police powers, no police authority. But the ordinance says what they can do. It's all participate, recommend, advise. And even down here on the record, in 12, direct access to relevant department personnel. Okay, but that doesn't have anything to say they have any authority to take statements off a police officer. They're not the chief. So I'm giving you language that incorporates what you said you want, that it was within the confines. If your intent is that you want some civilian border police officers to come down to some office, which is outside the police department, we have no knowledge of who's there. We don't know where the records go. They have no authority to grant any guarantee. And even if they did, where's the records going? There's no police officer there, some civilian. But what are they gonna do? Who do they have in the room? Now we know it's in the police department. Those records are protected from people who are not allowed to have access to it. What I'm giving you does what you said your intent is. If you accept that, then we can move forward. It says what you said you want. We don't accept it as part of Prop A, it's not.
So we just got our language, we're looking at it. Still need to discuss with the city attorney. But we understand what your point, your argument.
All right. Will we wait for your reply? I don't see the point of going on. If we can't, we agreed on all this. And you just throw a curveball at the last minute. City attorney, I can guarantee you couldn't tell you what's in this agreement. A lot of things on their plate. This is somebody who woke up and thought I could expand the power of the OPO. Get what the law allows. We're not agreeing for officers to be brought down to some show trial in order to get stay. No. If you want to stay within that IAD, we're not arguing. We're not arguing from day one. So I'm giving you what you say that sentence means. If you want more than that sentence, then you need to articulate it. That you have an ulterior motive to the language you gave me.
I'm not articulating what your language says, having just looked at it.
Are you articulating that your language is greater than what you said? What is the purpose of the sentence you brought? It's not to expand the OPO ability to take statements from officers outside of the police department.
Outside, inside the police department, it's just the language that gives them direct access without hindrance to
Okay,
the witnesses as determined.
but
by
that
the-
ain't anything. Not one word says they have any authority to take a statement from a police officer who works for the chief as a sworn officer. No civilian has that authority, period. And that doesn't give them that authority, and it does not say that access to people is different than I have access to you now. I have no ability to make you do anything. If your intent is for the OPO to take statements from police officers outside the confines of IAD, then just say that, because the ordinance does not say that.
I understand your position. That may or may not be the position we come back and agree to or
Well-
not.
Let us know, and we'll decide whether we're back next week, if in fact you're willing to do that. If your position that you gotta have it, you want access to police officers outside the confines of IAD, we're not gonna agree to it. We're not, and it doesn't require this.
I don't think that it was ever my understanding that you had at the table expressed that you thought that that was only within the confines of IAD, except for during the last negotiation session.
This language has been around. It says in the language that's been around that we used as a base, within the confines of CID.
I did not realize it said that prior to this.
Yeah,
time.
and
That's
yeah,
not what you're
that's
said.
part. Now, it's okay, because it didn't add any more things. But when you bring back this language, we gotta put back the language of which the city had agreed to previously. That language was in the prior,
In the confines of IAD was in the 22 TA.
that's correct.
The
And the city agreed to it.
Right,
And it was in our.
but not the 2018.
Right.
It was in our 2018 also. Back there, I struck that one part, that was fine, because we weren't expanding. And that's been on the table for more than 6 months. And now, so if I'm reading you right, you want expanded authority greater than we had before. Even when we had OPO in the contract, they didn't have that authority. And this does not say the OPO can order officers in, compel them to give a statement as a civilian. They have not. It says access, advise, participate. Not once in here does it mention a police officer can be compelled to show up and testify to anything.
So we will take your position back and consider it and read through your language. And
Well-
we'll see where we get.
The ball's in your court.
Did you, the other issues that we put on there, do we have answers on?
I hadn't just got them, I hadn't time to focus.
That's one of the
I'll look at them, but we gotta get over this hill. The rest are cleanup stuff. I can live with the margins of those.
Okay.
And if you get that done, we'll move forward.
We may not be anywhere.
We can live with that. We can. So.
I understand that.